This case invoked two principles in the subject of contract law governing clauses and novation. Firstly, law governing clauses. The court affirmed that the law regulating a commercial agreement between two parties is the place stated / chosen in the governing clause. This is the most important point in determining this. The law in the location the offer and acceptance took place, the law of the location where the contract was to be carried out, or the law in the location where arbitration was to take place, are irrelevant in determining the law that regulates the parties' commercial relationship where there is a governing clause. Secondly, the principle of novation. Novation is where the rights and obligations in a contract are transferred by one of the original parties to it to another new third party. The court held that under UK/English law, due to novation altering the most basic fundamentals of the original contractual agreement, it can only generally be done where the new third party to the contract agrees this in writing, not orally. The court further held that where this lack of a written contract is also supplemented by no oral modifications clause in the original contract, then most certainly no novation will be deemed to have taken place. The material facts were Kout Food Group, a holding company, owned the shares in the company El Homasi, a restaurant business. El Homasi had a franchise agreement with Kabab-Ji to become one of their kebab restaurant chains, but El Homasi breached this agreement, causing Kabab-Ji 6.7 M in damages. Kabab-Ji tried to sue the holding company, Kout Group, rather than El Homasi, but the court affirmed that the law which applied to the agreement was the law they stated did so in the agreement, which was English law, and under English law they were separate personalities legally with no novation having taken place, meaning no damages were owed. The facts of this case were that Kabab-Ji, a Lebanese company, who specialized in the production of exquisite Lebanese cuisine, high-quality Lebanese kebabs and other Lebanese dishes, and had an excellent brand reputation, entered into a franchise contract with El Homasi, a Kuwaiti company who were restaurateurs. This franchise agreement was that Kabab-Ji would give El Homasi the right to use its trademark, business processes, recipes and products, so that El Homasi could open a Lebanese cuisine restaurant in Kuwait for 10 years selling Kabab-Ji's much enjoyed and reputable Lebanese food. There were three important clauses in this license contract. Firstly, an arbitration clause. This arbitration clause stated that if there were any disputes then the matter would go to an arbitration organization based in France. Secondly, there was a jurisdiction /law governing clause stating that English/UK law would be the applicable standard of commercial law to regulate the agreement. Thirdly, there was a no oral modifications clause, stating that any time parties did things not in line with the contract this was an exception which did not become a term of the contract. Customs /favors did not become terms of the contract in other words. El Homasi was a subsidiary of a larger food and drink group called Kout Food Group, KFG, another Kuwaiti company. KFG provided holding company services for El Homasi and many of their other subsidiaries, which included advice in some contract negotiation processes. As well as providing general holding company services, KFG also manufactured food as a separate branch of their business which they sold to many of their subsidiaries. El Homasi and Kabab-Ji got into a dispute over the license agreement. Kabab-Ji argued that breaches of the license agreement by El Homasi had caused £6.7 million of damages. They were unable to resolve their differences, and arbitration was needed. Kabab-Ji did not take El Homasi, the restaurant they contracted with, to arbitration to resolve the dispute however. They instead sued El Homasi's holding company Kout Group, who were much better financed, and the matter went to arbitration in France. Kout Group underwent the arbitration under protest stating that they were not liable for El Homasi who was a separate person. The French arbitration held that due to the fact Kout Food Group helped El Homasi negotiate some of their contracts, the French law principle of novation ensured that Kout Food Group became a party to the contract with Kabab-Ji, and therefore had to pay the damages under it. Kout strongly disagreed with this and still refused to pay the money the French arbitration stated they owed Kabab-Ji. Kout sought to have the matter litigated formally in the English/UK court system. Kabab-Ji argued that it was the law of the arbitration clause which regulated the agreement, meaning it was French law rather than English/UK law that regulated the agreement. They argued that under the principle of novation in French contract law, which is very flexible, when Kout Group started helping their subsidiary Al Homaisi to some extent in their dealings with Kabab-Ji, then a novation took place, and Kabab-Ji's contract became with Kout Group instead of Al Homaisi. In other words, when Kout Group took an interest in this, a novation took place and they replaced Al Homaisi in the contract with Kabab-Ji. Kout Group argued first and foremost that them and Al Homaisi were two separate companies and two separate people/legal personalities. They affirmed they were the holding company of Al Homaisi, but stated that they had not interfered beyond their remit and beyond their basic duties as a holding company. They affirmed the general fundamental principle that holding companies were not generally liable for their subsidiary, unless there were exceptional circumstances, which there were not in this case. Kout Group then made arguments about the contractual principles invoked under the dispute and went through clauses /terms in the contract. They firstly argued that it was the law governance clause and not the arbitration clause which determined the law that regulated the agreement. They argued that this meant it was English/UK law governing the agreement, rather than French law. The arbitrators in France should have been applying English/UK law to the dispute rather than French law. Kout Group further argued that no novation took place under English/UK law, which has a stricter principle of novation than French law. They argued that under English/UK law, in order for a novation to take place, this must be done in writing to be valid because it is such a fundamental change to the original agreement, and this never happened. Moreover, they stated that there was a no oral modifications clause, meaning that any oral changes to the contract were not allowed anyway. Kout Group argued that it was clear that by the law of contract in England/the UK they were not liable for their subsidiary's £6.7 million damages bill. The court upheld the arguments of Kout Group, the holding company. They held that the law governance clause did indeed apply to ensure it was English/UK law regulating the agreement, and not French law. It affirmed that it is possible for any two companies anywhere in the world to enter a commercial agreement, and then use a law governance clause to choose which country's laws they wish to regulate their commercial agreement. They affirmed that the fact that the arbitration was to be held in France did not change this, and the French arbitrators should have applied English/UK law to resolve the dispute during arbitration. The court secondly affirmed that novation does require writing in order to be valid under English/UK law. In English/UK, two parties can initially form an oral contract. However, if a novation is to take place, meaning that one of the two parties in the contract is being replaced, then this must be done in writing in order to be valid. They further argued that where there is a no oral modifications clause, there is almost no chance of a novation being deemed to have taken place orally. In short, Kout Group were not liable for the damages of £6.7 million their subsidiary had caused by breaching their license agreement with Kabab-Ji.